This week for our Toil and Trouble employment law slot, I'm joined by Duncan Cotterill, Senior Associate, Jeremy Ansell. And Jeremy, we start with the Income Protection Insurance Scheme. Please explain what that is.
Sure. So this is very topical in the news at the moment. Essentially what it is, in a nutshell, is it's a form of compulsory income protection insurance that employees would have access to if the scheme goes ahead. So under the status quo at the moment, employees can take out their own forms of income protection insurance through private providers, but there's no compulsion. What this scheme would create is something very similar to how the ACC scheme operates at the moment. So employers and employees would both pay a levy in relation to a worker's salary or wages. That would go into a big pot, and if an employee was either made redundant from their role or was not able to work for a period of months due to medical illness or disability, then they'd be able to access payments for up to 7 months from this pot.
And National don't like this idea. Why don't they like it?
National don't like it. You will have seen in the media it's been called a jobs tax by the National Party. Labor's view is that it's filling a gap in the social insurance scheme. I think the political concern being raised from the right-leaning parties is that it's just another tax that, in particular, lower income workers may not be able to afford during cost of living crisis, etc. at the moment. Labor's view, flipping that around, is that it's an important safeguard to have in place for the large number of people who do lose their jobs due to redundancy. And some of the policy thinking behind this was that, for example, a lot of employment agreements at the moment don't have a redundancy compensation clause. There's no legal requirement to have one. So for a lot of employees, if they are made redundant, they don't have any access to ongoing compensation. And another factor in the thinking was that with the increase in technology and automation, there could be a larger number of roles that become surplus to requirements because technology effectively takes over.
Absolutely. From your perspective, you think there might be possible flow-on effects to the employment relationship. Can you explain what they might be?
I think with all of these schemes, there are often unintended consequences, and lawyers tend to pick apart these things and think about what those might be. Important to assess how it would work. So in the case of a person who's made redundant from their role, what would happen is they would have to be given 4 weeks of notice by the employer. The employer would then be responsible for paying what's called a bridging payment, which would be 80% of the employee's salary or wages for a 4-week period before the payments kick in, which they can then access for up to 6 months. But one of the issues we can see is how do you actually police whether people are actually looking for new roles while they're receiving these income protection payments for up to 6 months. From an employment angle, there's also concern about how this would apply to fixed-term employees. So the policy document says at the moment that fixed-term employees would be covered by the scheme up until the anticipated end date of the fixed term. But if you've got a fixed-term employee whose fixed term relies on a particular event happening and you're unclear when that event's going to take place, how can you then predict the number of months that the employee should remain on the scheme for? So there are some difficulties.
Sounds pretty complex.
Yeah.
You said the enabling legislation, is it making its way through the House at the moment? Where is it at?
That's correct. So the bill hasn't gone through yet, but what the government have passed is the enabling legislation, which would allow ACC to administer the scheme in the event that it goes ahead. So that's a pretty clear sign that they intend to go through with it. What we're expecting is that the first reading will happen early next year, and then of course, like any bill, it would go through the select committee process. Everybody would have an opportunity to comment on it, and I expect a lot of employers in particular will have something to say about it and the cost that they'll have to bear in order to make the scheme work.
Absolutely. And it's quite a thick bill, is it? Or the legislation?
I haven't seen the bill, but the consultation document
document
that's been released is large, and there's a lot of areas. I mean, you can see some of the benefits to it as well. You know, the medical coverage could be quite useful for a lot of people. For example, take somebody who unfortunately gets a cancer diagnosis, they're unable to work for a number of months, they have to go and have chemotherapy. At the moment, that person has no recourse or no remedies available under the ACC scheme because it's not an injury. But under this income protection insurance scheme, they would have access to up to 7 months of payments, albeit at 80% of their wages until they were hopefully able to return to workplace.
That seems reasonable. on its face, but yeah. Now, the next issue you raise is about sex workers and an issue that's been raised by the Prostitutes Collective. Can you explain what's happened here?
Yes, this is an interesting one. So the Aotearoa New Zealand Prostitutes Collective, they're a non-for-profit organisation that look after the interests of sex workers and performers. And important to remember that these people are workers like everybody else. They deserve protections.
Yep.
The concern that's been raised is that a number of these workers are being asked to pay significant bonds or amounts up front in order to even secure employment. Another concern that's been raised is that a number of them are having deductions taken from their pay without their consent. For example, one worker came out and said that she'd been unable to go to work at the club on a particular night because she was sick. She then got told the next day that the club were deducting $250 from her pay simply for being sick, which obviously if you're an employee you would have access to sick leave, so you would never be able to do that as an employer, but because these people are categorised as independent contractors and are on independent contractors agreements, there is unfortunately scope for some of these quite oppressive clauses to make their way in.
But is there scope for someone to just garnish your wages for being sick before you've even done the shift? I mean, is that legal?
I think it was done after. So that,
right, I see.
Deductions are an interesting area, right? So if you're an employee, the position under the law is that an employer can't just rely on a general deductions clause to make a specific deduction. There has to be some degree of consultation with the employee. So you have to say, I'm going to deduct this amount because you've damaged property, for example. The employee, of course, doesn't have to agree, but there has to be an element of consultation. But with the workers in the strip clubs, what's happening at the moment is that because they're on these independent contractor agreements, they have all these onerous clauses. The workers don't realise that the types of arrangements that they're signing up to would never fly in an employment relationship, so they just agree to it, and then they lose out money as a result.
And also the idea of paying to be employed. I mean, is that on its face legal, or?
It's certainly not legal in an employment context. So again, if it's an employment relationship, paying a large sum of money like that up front in order to even get the role would normally be considered what's called a premium, and under the Wages Protection Act, you can't have premiums in an employment relationship. But again, because they're independent contractors, not employees, these clauses are slipping their way into the agreement. So I don't know what the answer is. Maybe the government needs to issue some sort of guidance saying that in these contractor agreements you can't have clauses like that.
Does this have any correlation to the Uber dispute about employees versus contractors?
There's a lot of industries where the status of workers are unclear. The Uber driver area is particularly interesting, and that's been in the media a lot recently. Interestingly, in the case of sex workers and performers, there was a decision in 2018 that talked about the status of those workers, and two women took the case. They were actually flatmates at the time, working in the same club, and for a host of reasons the Employment Relations Authority found that they were independent contractors rather than employees. Maybe what we'll see in the future is a test case in that particular area. So any type of worker can go to the Employment Relations Authority at any point in time and get a declaration as to worker status, and we've seen it, like you say, with rideshare drivers, postal workers. There's been all sorts of workers who have done this. So there are more and more workers in different industries who are going to the Employment Relations Authority to find out a bit more about what their actual status is as a worker under the law.
And also the government's taking more of an interest in trying to legislate to protect in some ways.
Yes, they are. Yes, yeah. There's a group that's been set up that's going to look and hopefully provide some more guidance to everybody about what makes you a contractor, what makes you an employee, and there's even talk of a third category called dependent contractors, which is somewhat of a halfway house. Yeah,
that's right. And finally today, a dispute about hats in the workplace.
Dispute about hats. This is one of these quirky, interesting cases that employment lawyers enjoy reading about. So what happened here is there was a worker called Ms. Paztarova. My Russian's not great, but I think that's how you pronounce her name. She was employed as a store assistant in a store called Serious Straws down in Mapua by Nelson down that way. part of her role was to be responsible for arranging hat displays, because the store obviously sells a number of hats. And what happened here was her manager, a man named Mr. Sutherland, rang her up on the phone, berated her and said, "You're not displaying the hats correctly. They're out of order, they're on a slant, they're not looking right, they might be damaged," that sort of thing. The employee, Ms. Pastorova, went back into the store. She wasn't at the store at the time when she got this call. She looked around and couldn't see what on earth he was talking about or what the problem was. He then turned up to the store in person and continued to berate her. And there's a dispute over exactly what he said. She alleges that she was told she was the worst employee ever and that he screamed and shouted at her, etc. But to cut a long story short, she had her hours reduced down to 4 hours on a Sunday only, down from about 3 days a week, and eventually resigned. So she took what's called a constructive dismissal case to the Employment Relations Authority seeking remedies.
And she won.
She did win, and she got a decent compensation amount, $20,000 compensation plus lost earnings. And basically what the authority found was that it was foreseeable to the employer that behaving in the way that he did would lead to her resigning. It was considered a breach of the employer's duties to shout and berate an employee, including in front of customers, but also to unilaterally reduce her hours down to 1 day per week without her consent. So I guess the lesson there is if you have these dramatic outbursts as an employer, even if it's about something as trivial as hats, it can lead to a costly day in the Employment Relations Authority.
Jeremy, thank you so much.
Thank you.